Now, we talked about there being a lot of changes here in 2022 on Court TV. One of the changes is that plea day has been added to the afternoon of these miscellaneous dates. Now, plea day, as we call it, some people call it arraignment if you're in a different part of the country, some people call it arraignment here. That's really the first time someone is in court. Now, on plea day, you're going to see it's going to go very fast. The plea day part will go very fast. You're going to have people who haven't hired a private lawyer or are assigned to the public defender. If someone has hired a private lawyer by that point, that lawyer is going to file a waiver, what we call a waiver of arraignment, and a not guilty plea. So, for instance, that's what I do for my clients. My clients aren't going to go to plea day. But when I was a public defender, all of those clients go to plea day. A lot of times it's the first time a public defender is going to see that client. They're going to give them a card, they're going to set them an appointment, and they're going to get ready for that next court date, which is pretrial conference that we talked about in another video. This is a change because plea day last year was on a different day. It wasn't intertwined with this. This has actually streamlined it, put it all in one day. It does seem like it's a lot easier to take care of. After the plea day part goes, and that part goes rather quickly, then starts the afternoon of the miscellaneous VOP court date. The afternoon is reserved for larger hearings or contested VOP hearings, and I know we talked about those earlier. There's not a lot of those, but they do happen. But those other larger hearings, things like sentencings, when someone has entered a plea to a case, and now they're going to come back and get sentenced by the judge, and they're going to bring in, people to testify. They're going to bring in their friends or family to speak on their behalf and bring in letters, and we're going to hear that compelling testimony about maybe why they should get less than what the state's offered or why they should get this or that. And those are always very, very entertaining, very riveting to watch. I know even here at the office, we stay glued to Crestview Community TV on these afternoons.
Scott Frost.
You should have blue and serious touch involved. Like I think that you should be that should be
You know what it is. It's okay. Do you guys have a brand? I think so. That sounds familiar. I think it's a good case of mine.
What's this last name?
It says the last name.
Brandon.
Okay, a new case of mine. Just trying to find out somebody for that place. Oh, thank you.
All rise, please. Circuit Court is back in session. Please be seated.
Mr. Medina, who wants to go first?
I have a couple of that may call, if that's okay, Your Honor.
Why don't we try the out of
Yes, Your Honor.
custody, and then we'll do the ones that don't have lawyers.
Thank you, Your Honor. First would be Tyra Booker. She's number 3 on the afternoon 1:30 docket.
I'm sorry, say the name again.
Tyra Booker, Booker, number 3, 23 CF 1891 and 23 CF 1892. And Your Honor, at this time, Ms. Booker will plead not guilty.
Very good. The court will enter a not guilty plea, and we'll come back on our next pretrial conference in, let's see, October 9th.
October 9th. Thank you, Your Honor. Do you want me to write that down for you?
It's at 9
I gave you
a.m.
my
in the
card,
morning.
right? Yes, sir. All right. Thank you. Call Vicky. Okay. Thank you.
So, Your Honor, you want this on October 9th, right? Because it says 10/11 on here.
I think it's because she was previously in custody, Your Honor.
Okay, good.
Next will be Thomas James Bouchard, Bouchard, number 4 on the 1:30 docket. Bouchard. Mr. Bouchard is before the court in 23 CF 1882. And we've asked the state to consider PTI in his case, and the state has not made a decision on that. And if we can enter a plea of not guilty and ask to be put on the 10-9 docket if we're not already.
Very good. Court will enter a not guilty plea, and we'll come back on 10-9. If you're able to get a plea and want to get it earlier, we'll try and get it on.
Thank you, Your Honor. Yes, sir. I think those are, oh yes, one more, Your Honor, out of custody. Number 8 on the docket, Kevin Joseph De Lorenzio. Mr. De Lorenzio is before the court approaching in 23 CF 1858. He would like to enter a plea of not guilty, Your Honor, and be on the October 9 docket.
Very good. Court will enter a not guilty plea, and we'll come back on the pretrial on October 9th at 9 a.m.
Thank you, Your Honor.
Now, Mr. Medina, I've got several other non-inmates.
I just haven't made contact with them yet. They're probably on their way up here, let's hope.
Okay, we'll just assume that.
I just got one, Your Honor, right now. I'm waiting for the interpreter on my other. Cody Frazier's client stepped into the bathroom, so if I can pass him, or if the court will allow me, I'll enter not guilty plea on his behalf.
Who's that? Frazier?
Cody Frazier, yes, Your Honor. I talked with him this morning. The state did make an offer We like to review discovery before we take that offer.
You anticipate him being here?
Yes, Your Honor, he is here. He stepped out to the bathroom.
Okay. Very good. If you represent that he's here and you want to enter not guilty, that's fine.
Yes, Your Honor. He's got October the 11th as well, so if we can announce it as October the 9th.
Very good. Court will change the pretrial to October 9th. He's out of custody.
Thank you, Your Honor.
Your Honor, one other person, this is more housekeeping, but we entered a written plea of not guilty for Christina Nicole Bradshaw, number 5 on the 130 docket, 23 CF 1870. So we've already done a written plea of not guilty for Christina Bradshaw.
Very good.
And also, Eppinger is off the docket already.
Well, hold on a second. On Bradshaw, our next hearing is just the pretrial 10-9.
Yes, I'm glad you raised that, Your Honor. She has a motion hearing. I think it is October 17th. If Madam Clerk can confirm that, I would prefer that we continue everything to the motion hearing date.
No, sir, I don't even have a motion.
Okay, well, it's not in this case. It's another case. She has 2 or 3 other cases.
You want to run all the cases together?
Yes, Your
Do you
Honor.
by any chance have the other case numbers?
I normally would, but because of the...
Clerk's got it.
not guilty, I
Yes, a
don't.
motion hearing on 22 CF 246 with Your Honor at 2:30 on October 17th.
Okay.
So, Mr. Bradshaw on that date as well.
What's the motion?
She's already off the docket.
Your Honor, it's a motion in limine.
It's a motion in limine, lady, it's an expert, it's a 2:30. I think it's already been set with Eileen
Sure.
and, or your Honor's judicial assistant to be more formal. And, we have an out-of-town expert appearing by Zoom.
Okay.
And the state's calling an FDLE expert, so I think
Okay.
it's a full-blown.
Very good. So we'll run, let's make sure and announce, so this case 23 CF 1870, and then what are the other 2 numbers, and we'll run them all together?
I don't know, I'm sorry.
22 CF 246.
Okay. Is that the only other one? Just
One
one
other
other one?
There's a VOP too.
Yes, there's also a DOP 18 CF 1569.
Okay, so we'll run all those together, and we'll come back at that hearing, the hearing on 10/17.
Your Honor, 2 other administrative issues, may I?
Sure.
Eppinger, Ms. Basso was reminding me, we're in Shanice Bianca Eppinger. She was taken off the 130 docket because we did do a written plea of not guilty for her already in 23 CF 1864. So I don't
Okay.
think Madam Clerk has paperwork for her.
No, sir, I don't.
And then also written plea of not guilty and taken off the docket were Brandon Scott Barker, 23 CF 1865, and Stephen Gabriel Arnett Jr., 23
Well,
CF.
let's take them one at a time, because I want to make sure we've got
Yes,
hearing
sir.
dates for all of these.
Yeah, of course.
Let's start with Miss Eppinger. So written not guilty, coming back on pretrial,
Yes, Judge.
10/9.
And we have a
Yeah,
deep,
this is important because it's set for 10/11. Okay.
she's out of custody.
Okay, so.
That's all right. We'll get it. We can just change it.
And we have a DPA proposal, so I anticipate that coming off the docket. I'm meeting with her very soon.
That's fine.
Thank you.
Okay, what's the second one you just?
I'm sorry, Judge. The second one is Barker, Brandon Scott Barker, was already taken off the docket. But just indicate, somebody got an old docket.
Sorry.
He's on the new Judges 10/11 pretrial conference and also set for vet court. Are you aware of that?
Yes, I think he's going to be observing in vet court. I don't think he's going to be doing vet court. He might, but I'd rather have him on 10/9 without a custody, if that's okay with the court.
Excuse me.
Could we do 10/9?
Yes, that's fine.
And then the last one that I know was taken off the docket was Stephen Gabriel Arnett, A-R-N-E-T-T Jr., 23 CF 1878, with a written plea of not guilty. And he was here this morning, but I told him to leave because we'd already done a written plea of not guilty.
Okay, and we'll come back on that on 10-9 as well?
Please.
Okay. They good in that? Okay, good.
And I'll see if I can find any other clients, Your Honor.
Okay.
I have that same in custody.
Any more of yours? I've got some that don't have attorneys, so I
I
can.
would say take those, Your Honor. I still need an interpreter.
Okay. Is Cameron Eddy here? State?
Judge, state would request to take this. Mr. Cameron, I was looking at the clerk notes in this case.
Eddy. I think his last name is Eddy.
Oh, I apologize. Mr. Eddy, he was told to be here, and he also said he was going to hire an attorney.
Okay. Thank you for checking. I was going to ask you about service. Court will issue a no bond case.
Judge, actually, I apologize. I'm looking at, I'd like the clerk's notes on this, but on the felony plea day minute sheet, it said that the upcoming pretrial conference was set for October 9th.
So we've already done an arraignment on him?
I think so.
Is there an information on the case? Because I'm showing that it was put on today for an information. And yes, sir, I do have it set for October 9th. But Judge put it on today for the information to be filed in 23 CF 1420.
I apologize, Judge. I think I got my dates mixed up. The information has not been filed yet, but I'll file it when I get back to the office.
Okay, so we generally have to come back in order to enter a plea. So, let's see. Today, November 19th. The next plea day is not until
October the 12th.
October the 12th. But that's after the pretrial.
If I have it filed by pretrial, can he enter a plea at that time?
I think we ought to just come back on arraignment.
Okay.
And so let's come back, let's keep them on the right day.
Just so.
So October 12th.
There is some information in 23 CF 114.
And that's, I was gonna say, that maybe, because he's got an information in one case, he'll be here on the 9th in that case anyway.
Okay.
That's what I think, I think that's what the state was trying to get to.
You got PD helping you out?
Thank you, Judge.
It just,
Okay, come back, no, that's good, let's run them together, 10-9, and he can take a plea at that time.
and
Make a note that he does still need to make a plea. Okay, and obviously withdraw the case. I'm gonna take a 5-minute break.
All rise, please.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma.
Yes, sir. This is Patrick Terrell Hart.
Okay. The state would announce this is under Mr. Switek's name. This is 23 CF 1058. So, Mr. Hart, at this point, I understand you have not retained Mr. Switek?
No.
Are you planning on retaining?
No.
Okay. So this is a violation of probation. Hearing is kind of like an arraignment to make a plea. Are you wanting the court to appoint an attorney?
Oh, I'm willing to plead for.
I'm sorry?
What the state is offering.
What is the state offering?
The offer is to modify probation to add 12 months of community control, reinstate to complete original terms.
I'll take that.
Okay. Is that an additional 12 months, or are you changing 1 year of standard probation to community
It
control?
would be an additional 12 months.
Okay. Very good. You understand that, sir?
I do.
Okay. Raise your right hand. Let me just ask you a couple questions. You swear or affirm that the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes.
Okay. So you can put your hand down. So I just want to make sure you understand what you're doing.
I do.
I'm not trying to kind of rush you through this.
I appreciate
So you
it.
heard the state make their offer, and their offer is very, very straightforward, to add an additional 12 months of community control. I don't have all of the requirements on your original probation, but anything you have still to do, the cost, the fees, any kind of assessments or anything you had to do, you still have to do.
I understand.
Okay, but we're adding community control.
Right.
Community control is a little higher degree of supervision. So all I'm saying to you, you need to be committed to that. You need to pay attention. You get up every morning and say, I got to deal with this. Because the next step you're not going to like the next step.
I understand.
And probation, community control.
Prison. I understand.
I mean, it's not guaranteed, but it may not always seem like, but that's not what we want. I don't want you to go to prison. I want you to stay here and get your stuff done, be back in the community doing the right thing, okay? So you willing to do, you understand that?
I am.
Okay. Very good. And you understand this is the final resolution of your violation of probation?
Yes.
You're giving up the right to go to a trial and contest and all that. You
Yes,
understand all that?
I do.
Do you have any further questions about it?
No, I don't.
Okay, very good. Based upon that, the court will accept the state's offer and the plea and add an additional 12 months of community control on the original. All other terms and conditions of your probation will continue as is. Okay? Question?
What city does it live in?
Where do you live, sir?
Mary Esther?
Yes,
Mary Esther. And he needs to, as soon as he gets out, he needs to go visit you all, right?
Yes, sir.
Okay. Got it?
Thank you.
Thank you. Okay. See if there's, do you have something else?
They're not here. I'm reaching out to my office to see if we have any information about a couple of them.
Let me see if there might be a couple of people without attorneys.
I can take one, Your Honor. I did have one show up, but I thought that.
Oh, yeah? Go ahead.
Mr. Frost. Scott Frost, Your Honor.
Got it?
Mr. Frost is before the court in two cases, or actually one case. It's 23 CF 1836. Mr. Frost does actually have a second case, 23 CF 2025. The state has filed an information in both cases. If I can enter a not guilty plea in both cases, Your Honor, he's scheduled for October the 11th of one and December the 11th in the other case.
So why don't we put them both on October 11th?
I was asking Mr. Frost.
October 9th.
If he would prefer it if we could do it December, he and I have no discovery, so that'll give me time to try and get some of the discovery in both cases, review all that, and if we need to resolve it, we can move him up a court date.
So you want to come back December 11th?
Yes, Your Honor. My October 11th date is getting a bit packed as it is, and the
Okay.
9th.
Very good. October 11th, 9 a.m., okay? And be in touch with your attorney in the interim, okay?
Judge, you said October 11th.
It's December the 11th.
December 11th, thank you.
I'm gonna write it down.
Yep.
Don't leave yet, okay? I'm gonna give you some paperwork to fill out.
Okay. Appreciate it.
All right. Thank you, Your Honor.
Thank you.
Let's see here. Is Christopher Higgins here? Christopher Higgins. 23 CF 1896. Would the state confirm that he's gotten service or was noticed?
1896?
I think he's an inmate.
No? Well,
He's an inmate.
he's an inmate? Okay, don't worry.
Can we get number 44 and 45? There's also one unrepresented person speaking English. We'll have to wait for the
Interpreter.
Okay. Mr. Higgins, the lectern. Higgins, this is.
Good afternoon. Would the state please announce? Christopher Higgins.
This is State versus Christopher Higgins, 23 CF 1896, charged with possession of a controlled substance. If you'd like to resolve this today, the offer is a withhold of adjudication, 3 years probation, court cost. You have to complete a substance abuse evaluation and any recommended treatment, and you'd be subject to random error analysis for 3 years.
Okay. Mr. Higgins, hold on a second before you even respond to that. You do have a right to have an attorney appointed so you can talk with an attorney before you accept or whatever with, if you want to do something. So my first question to you is, do you wish to have an attorney appointed or you want to consider the state's offer?
You know what, I was wondering, I'm also in for poetry. Could y'all put them together?
You're not here on that case today.
Okay. I'd like to have an attorney.
You want to have an attorney
Yes,
appointed?
yes.
Okay. Court will appoint an attorney, and the court will enter a not guilty plea and will come back on October 11th at pretrial. You have a chance to meet with your attorney, okay?
Okay.
Thank you.
Thank you.
Who is this?
This is Hutchinson. I figured he might be next.
No, he's good. So, Mr. Hutchinson, this is case number 2023 CF 1854. You're here on, this is an arraignment today where you're making a plea. So state,
That's,
if you wish to consider any the state's offer, you can do that. But the main purpose we want to do is to get a plea here and to appoint you an attorney so you can talk with an attorney. Counsel?
the state's willing to offer today an adjudication of guilt, 12 months on community control, followed by 12 months on regular probation. He would have to pay court costs, have a substance abuse evaluation, and any recommended treatment. And his driver's license would be revoked for 1 year. He'd also have random urinary analysis as part of probation.
I know he said that pretty fast, but, you do have a right to an attorney if you want to talk to an attorney about this. And, I'll enter a not guilty plea here today. So I know I'm throwing a lot at you, but.
Yeah, I'd like to speak to an attorney.
Okay. So the court will appoint the public defender. Now, you do need to fill out the form and whatnot, but the court will enter a not guilty plea. We'll come back on 10/11. Yeah, 10/11, October 11th, pre-trial. It'll give you a chance to speak with your attorney about this. Okay? Thank you. Is Scott McGilvery here?
He's quite quiet, I think.
I've got him down as a no attorney. I'm not saying he's not yours, but that's why I called his name. Would the state look this up, make sure he's been properly noticed? 23 CF 1663.
One moment. It looks like notice went out on 9/13 to his bondsman about today's hearing.
When? On the 13th?
On the 13th, September 13th. It also looks like notice went out on the 13th. I think that went to Mr. McGilvery too. That notice lists his email address. I don't know if that means it was
Listed
emailed.
what?
His email address? Does that mean that the notice was emailed to him?
Who would have done that?
The defendant.
No, sir, we mailed it. It's docket entry, that was for 9/12, but it came back because he's at general delivery. We don't have an address for him, nor do we have an email, but we do have his bondsman, and we did notify Mr. Marquez.
Well, Judge, it sounds like he's been noticed properly, so the state's going to request a KPS.
May I advise the court of something? Sure. I recognize the name, and indeed, the public defender and myself personally, well, in my capacity as assistant public defender, in 23 CF 1350, Mr. Scott Francis McGilvery, which appears to be the same person, already has the public defender in 23 CF 1350. Had I known that he had this additional case, I would have possibly done a written plea of not guilty. Can I?
Let me ask you this. What is the next court date for 23 CF 1350, if you got it?
I'm looking that up, Your Honor. That appears to be October 9.
Well, seems that he's got an attorney in that case, why don't we go ahead and appoint the public defender, enter it not guilty, then we'll come back on 10/9, which when we deal with both cases.
Really appreciate that. Thank you, Your Honor.
Mr. Medina made. Could you give Mr. Medina that information on the delivery, please?
Thank you.
Un moment.
Thank you.
Your Honor, I have, we're ready for another.
Sure.
This is Dennis Wilfredo Gomez Machado.
Okay.
Good afternoon, Your Honor.
Good afternoon.
Ms. Gomez Machado.
Gomez, okay, gotcha. Okay, good afternoon. You've been charged with 2 new cases. One is 23 CF 1833, possession of cocaine, and 23 CF 1834, which is aggravated battery. You do have a right to have an attorney appointed in these cases. If you cannot afford one, one will be appointed for you. Do you wish to have an attorney appointed?
Yes, sir.
The court will appoint the public defender in both the cases. And the court's going to issue a not guilty plea on your behalf. That will allow you to meet with your attorney and you won't give up any of your rights. And we will come back on 10/11, October 11th at 9 a.m. And you'll have a chance in the interim to meet with your attorney to discuss the case. Does the state just, I don't know, who would that be appointed to? Mr. Gates? Does the state, just for Mr. Gates' benefit, does the state, have they considered an offer?
The offer is an adjudication of guilt, 25.95 months DOC and court cost.
Okay. Do you hear that, Mr. Gates? You got that? Okay. Okay, so we'll come back on October 11th. In the meantime, meet with your attorney. He'll come visit you. Do you have any questions?
My question will be regarding my bond, Your Honor.
Talk to your attorney about that as well.
Okay, Your Honor.
Thank you.
Next, Your Honor.
You have one more?
Yes, sir, I do.
Who's the next?
He's represented by Mr. Gates, and his
Mr.
name
Gates?
is
What's the name? Sorry.
Gomez
Gomez also.
Glory
Go ahead. Yes, I got it.
Joseph.
Very good.
Who is this?
Gomez Glory Joseph.
Yes,
Hyphenated last name. You got it?
Yes.
Okay. Go ahead and announce, please.
Yes, Your Honor. This is Mr. Gomez Gloria in case 23 CF, make sure I get it right, 1901.
Correct. That's right.
At this time, we'll enter a not guilty plea. I know the state was discussing the potential PTI offer for Mr. Gomez.
That's correct. We are offering a PTI in this case, Your Honor.
Okay, so you just want to come back on 10/9?
Yes, Your Honor.
We'll come back October 9th at 9 a.m. But in the meantime, you need to coordinate and meet with your attorney to go over. The state has made an offer, and you need to talk with your attorney about how to resolve the case, okay? You have contact, did you give him?
I'm going to have him fill it out.
10-9.
10/9.
¿Vas a regresar? A las 9 de la mañana, esto es octubre 9. A las 9 de la mañana aquí. Okay? That is all I have, Your Honor.
All right. Thank you very
sir.
much for your assistance.
Yes, sir.
I have one
Go ahead.
advising the court. My office advised me relating to Angelique Clarice Croxton, Croxton, 23 CF 1861, that mail was returned undelivered. I don't have any further information, but there may be a problem of address or service on that case. I wouldn't want failure to appear, Your Honor.
Well, I understand that, but it's his obligation if he moves to.
The female, Your Honor, but I don't think there's notice. I don't think there's proof of notice.
Well, Your Honor, we sent notice to 228 Jefferson. I don't want to shout out the address. And
All I can do is send it to them, and depositing it is actual, I believe, depositing in the depository of the U.S. Postal Service constitutes service. I believe, don't they? If it's by mail.
I don't think I think there's basically proof of not actual service would rebut any presumption of delivery.
State?
And
Your Honor, I also did, I wasn't, have we called that case yet? I don't know if he's.
Okay, so it was sent and it was sent back. So it sent it, the clerk sent it to the address they have, it was sent back.
Your Honor,
Counsel for the defense is
Can I just
saying that
say-
this is not proper service. And I was always under the impression that service was completed by depositing it in the.
I think that's a presumption.
Service, yes. Notice, no. So that would be the subtle difference, Your Honor, because that's what I usually will say to the court. I don't think they got notice of the court date. Service would be a different argument. I'd also think if,
What are we supposed to do if they move? Aren't they obligated to inform the court or at least their attorney if they're gonna move?
we cannot comment on any of that, Your Honor. The Florida Bar has been very clear on that.
You can't comment on anything that might be detrimental to your client. I understand.
And I
So that's why I'm asking the state to argue it a little bit.
Can always enter not, Taylor.
Your Honor, I think I can, if the court will permit me, I will just, orate tennis center of not guilty plea for Angelique C. Croxton. I do have a file for the individual, but not met with him.
I'm sorry, Judge, I was looking at if there was a court date on the bond issue. I saw it, it said September 25th.
Court will enter a not guilty plea and we'll come back on 10/9 at 9 a.m.
Thank you. My other one that I don't have any information on is Jake C. Bell, B-E-L-L, 23 CF 121927. If the court will permit me, I'd like to enter a not guilty plea, but I've had no contact.
Has he been properly served? I know we've been having a lot of trouble with notice and service, and that's why I'm asking this.
I think
If there's some question, I'll do it, but I'm not gonna carte blanche, just allow people not to show up and just because they previously had an attorney, I don't think they.
Bell, Jake, B-E-L-L. I did not
The
have
address
any
that we
information.
have on Mr. Bell is at large, so.
So it's kind of hard to serve at that place.
We're looking for him.
And Your Honor, I'm looking at the signature bond that he signed, and it tells him to appear on September 26th as well.
And the clerk did note that there was an address on that bond of 190
But
We sent notice and it was returned.
For the record, today's not September 26th. Is that what you said?
Yeah, it says September.
Just that, yeah.
I didn't pick that up, so I did. I appreciate your reminding.
That was my point, Your Honor, is that it's not.
I heard it.
I'm sorry, I wasn't listening.
That's all right.
I wasn't trying to be,
The clerk sent has to today's date.
What's that?
The notice that the clerk sent has today's date.
That's right.
If that helps. To the student address that got returned.
We probably need to maybe sit down and try and figure out, because we're having an awful lot of these that are no-show.
And I think the last time we had that issue, I spoke with Eileen and I expressed, I think the issue is these court dates were set out. So when they get the signature bond, the courts, they're looking at the old docket. They don't have the updated docket where the court has moved one of the plea dates to a different court date. So some of these are corresponding with old plea day dates that they got when the court first started on the docket. So I think that's part of the issue.
More broadly, Your Honor, is that there's simply been an appointment at first appearance of the public defender. We don't have any information. We might have a file open and have absolutely no contact information, so.
Okay. So the court will enter a not guilty plea on Bell and come back on 10/9.
Thank you.
Retrial. Okay. Let's see where we're at. Do you have
Your Honor, I have
Israel case? Yes, sir.
You wanna, this your client, Mr.?
Yes, Your Honor, Steve Medina with Israel case, Israel J case in 23 CF 1951. He is number 6 on the docket. I'm going to enter a plea of not guilty on his behalf. If we can move him, he doesn't need to be on the December pretrial. Can we put him on October 11? And I'm hoping we can get a resolution. My investigator I got with, and she's sending him a bunch of information about some places that might be helpful for his consideration.
We'll enter a not guilty plea and we'll come back on October 11th, 9 a.m.
Thank you. Okay. In your, just look at the thing here.
Gates?
Mr. Garland?
Garland, that's an inmate?
Yes, Your Honor. 5 hats at once this morning. This is Mr. Garland before the court. We have a plea agreement to be filed in his case. It would be a plea to a lesser included offense if I can approach, Your Honor. It's a misdemeanor, so there would be no solution necessary.
Okay. Would you please announce the plea?
Yes, Your Honor. Mr. Kevin Garland's before the court in 23 CF 1853. The state has agreed that if he enters a plea to the lesser included offense of petty theft, they would recommend, and the sentence would be withhold of adjudication, $270 court cost, $150 public defender fee. Mr. Garland's asked for 24 months from date of release to pay those outstanding fees.
State?
That's correct, Judge.
Mr. Garland, would you raise your right hand, sir? Do
Well,
you swear or
Judge-
affirm the information? I'm sorry.
I apologize. I should put this on the record.
Sure.
Give me one moment.
Okay.
And Judge, I'm just confirming that we had victim contact
Okay.
with Miss Burnett. That's correct. So I did attempt to contact her and speak about resolving the case this way. I was unable to. I do see that we had an input form in the file. So she did make her wishes known to the state. So I would say that we can proceed and we've complied with Marcy's law.
And I put on the plea agreement, Your Honor, defendants entering the plea without reviewing discovery. It is a withhold of a misdemeanor court cost. It was my understanding that the victims in this case had requested the charges be dismissed. As earlier the state's position was, we take that into consideration. This is kind of a middle ground between dismissing and a resolution. Considering it's a withhold of a misdemeanor, Mr. Garland was more inclined to take that because it would result in his release today.
I would agree with that assessment.
Okay. So we're just having a withhold of adjudication and
Court cost.
I guess it I guess technically it would be credit for time served.
Can't announce it as with the withhold, Your Honor.
Okay, well, we won't announce it then.
Yes, Your Honor.
Okay. But it is a final adjudication. There's no probation, no further.
No, Your Honor. No, Your Honor.
Okay. Mr. Garland, did I swear you in?
No, Your Honor.
Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
So, and this is the agreement for the state. You can put down your hand.
That's correct.
Okay, you can put down your hand. Okay, so you heard Mr. Garland, your attorney state the terms of your plea agreement. Pretty straightforward. Withhold of adjudication, some fees and costs. You'll have 24 months to pay before it gets sent to collections. There'll be no further probation, no probation, no further incarceration. You'll be able to get out immediately.
Yes, Your
Okay,
Honor.
is that your understanding of what the plea agreement is?
Yes, Your Honor.
And you understand this will be a final resolution of your case. You do have the right to go to a trial and contest all this. You're waiving that, saying, hey, I want this thing resolved, put it to bed. Is that what you want to do here today?
Yes, Your
And you
Honor.
believe this is in your best interest?
Yes, Your Honor.
And you had all your legal questions answered by your attorney?
Yes, Your Honor.
Okay. You've done a good job. Has he done a good job for you?
Yes, he has.
Yeah, I think he has. Okay, very good. Based upon all that, the court will accept your plea here today. There'll be a withhold of adjudication. You've got $270 in court costs, $150 public defender fee, and you'll have 24 months to pay before it gets sent to collections. And just there was an acknowledgement that you had not been able to go over discovery, etc. Okay? Good luck.
Yes, sir. Thank you.
Rudolph McKinnon.
Steve Medina with Rudolph, McKinnon, Junior, it's Junior, right?
Yes.
In docket 18, 23 CF 1782. If I may just give him some information, Your Honor.
Sure. I don't have that. What is it on?
Your Honor, Mr.
Would you, it's not on my document.
I'm sorry, Judge.
Repeat the
Rudolph McKinnon Jr.
Okay,
I thought it was docket 18.
okay.
I may be wrong.
What about page 8, number 23?
I don't have a docket in front of me, so I'm just
Yep,
letting you
there
know
it
what's
is.
on my cheat sheet.
Nope.
Rudolph McKinnon.
She found it for me.
Thank you, Your Honor.
It's out of place.
23 CF 1782.
Yes.
He will enter a plea of not guilty. Could we put him on October 11 if he's not already on there? We're
You may.
looking at treatment options for him.
Very good. The court will enter a not guilty plea and we'll continue this matter until October 11th at 9 a.m.
Thank you.
Okay? Good luck.
I have Mr. Cooper ready for the 2:30.
You don't want to?
If you're done with it.
Yeah, let's hold on, Mr. Cooper.
Okay.
for a second, please.
Okay, yes.
It's a few minutes.
So that's your information, that's your minute sheet.
Did we do Gillespie, Mr. Gates?
I entered a not guilty plea on his behalf, Your Honor.
Your Honor, on my 2:30, I did need to speak to Mr. Cooper.
You want to talk to him?
I need to speak to him at attorney
And
client.
Mr. Gates, Mr. Henderson,
Same.
Diamond Henderson,
I entered a not guilty plea, Your Honor.
was it a written one?
Yes, sir. They were filed yesterday before lunch.
That's all right. I'm just trying to kind of figure out.
Yes, sir. The state and I have been in discussion with Mr. Henderson's case. My anticipation is a resolution on the 9th. And then on Gillespie, the state and I are in conversation about resolutions and next step.
Okay, so both those will come back on 10-9.
10-9 on Henderson, 10-11 on Gillespie. Mr. Gillespie's in
And then I've
custody.
got one other name on here, Jakeem Scott.
Judge, if I may, I'm kind of interested in why this one's on the docket. I have two different case numbers for this defendant, both coming from similar fact patterns. I know that he's represented in the other case, but not in this
What is
one.
the other case number?
The other case number is 23C, one second. It's 23CF 385. And so I've been speaking with the defense attorney in that case. His name is Lyle Mason, and he's from South Florida. He did a motion to continue in that case. I don't know if for some reason he's forgotten to enter his appearance in this case, or if he might not know about this case. My point is, I don't see the defendant here, and I don't see his defense attorney. I'm not asking for a case because I think this stems from genuine confusion.
And so you're kind of in your communication with him, did you say there were similar, are you kind of under the understanding that he's representing him on both charges, or at least he might be?
I don't want to say that that's not my understanding, right? I'm not quite sure what's going on with this.
Well, we do know there's similar charges, and when is the 23 CF 385, when is that?
It's set to go to the court on October 9th, so I would expect.
That's just pre-trial.
Right, so if we could track this.
So we haven't pled yet 1860.
I understand this.
So let's go ahead and just track both of them for 10-9, but make a note that he has not yet pled in the case before us today, 23 CF 1860. So we're continuing the arraignment on that one until 10-9, and then the other one will be pre-trial for 10-9.
Okay, and I'll email Mr. Mason and let him know that. That
Okay.
way he's brought into the fold. And
we'll at least deal with him at the same time at the next hearing, even if he's not the lawyer.
Thank you.
I appreciate you raising that issue. Mr. Gates, are there?
There you go. Trying to catch up on my minute.
That's all right.
I'm ready to go with Joshua Cooper whenever the court.
We're ready for
I will say, Your Honor, the court on Alexander Gillespie said October the 9th. It should be October the 11th. He's an inmate.
Thank you. Gillespie, October 11th. So not guilty on October 11th. Did you get that, Madam Clerk? It's 1817. 23, 1817.
Yeah, you want to give that to us?
Madam Clerk, what court date did he give Gomez Gloria Joseph?
I showed 10-9.
Okay. Because I had December 11th on my file.
Yes, our judge said 10-9, so I marked it off.
Okay, Mr.
May
Medina.
we proceed, Your Honor, on the 2:30 docket?
You may.
If I could bring Joshua K. Cooper before the court, 20 CF 2872. May I first inquire, did the court receive our sentencing letter?
I did. I received it late this morning, but I did review it over the lunch hour.
I'm sorry, Your Honor. I did it yesterday and emailed
I got it.
I apologize for the short notice.
Better late than never, as they say.
Yes, Judge. Thank you. May I approach also the score sheet, even though there's a cap that's at 20 months?
Does the state review it?
The state, it is the state score sheet.
That's the correct score sheet.
So just so the court has that.
Okay, thank you.
Address this issue, Your Honor. Your Honor, at this time, basically, I don't have an opening statement. My letter is my opening statement. And just to let the court know, Mr. Cooper wishes to be sworn and just provide a statement to the court. Obviously, he's subject to cross-examination if the state's inclined. And other than that, I may have a few extra things to say after he talks, Your Honor.
Very good. Mr. Cooper, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay. Slide over and talk into that microphone so I can hear you good.
I'd just like to say, if you find it allowable that, I'm really not out there catching any more charges per se. I have a drug addiction that I need help with. And whenever I left the Keaton house, I tried to tell them that I wasn't ready to go back out, that I'd probably relapse. And they said, well, your time's up, we have to let you go. So when I went back out there, I was homeless. I didn't have anything going on. I was around the bums per se, and I got kind of coerced back into the same drug addiction. If you could allow me to, I'd like to get some more treatment for it so I can become a productive, presentable member of society and not a criminal.
Who is the state who wishes to?
This is my case, Your Honor. The state is asking the court for the 20-month suspended sentence. If the court takes a look at the guidelines, had that suspended sentence not been imposed on previous violations, his minimum exposure would be 30 months and some change in Department of Corrections, according to the score sheets that would have applied had he not had a cap on incarceration. The state does believe the 20 months should be unsuspended. Your Honor, this is his, by my calculation, third technical violation in this case. His violation report does take note of the fact that when this urinalysis came back from the lab, that it had was noted to have extremely high levels of each of the substances in his system, and that was of note to the officer. It does look like previously, back in 2020, he did go to, he did do some substance abuse treatment, and he was to do aftercare, which remains not completed on his violation report. Your Honor, given that the underlying charge in this case is alleged that he was in possession of a gun in contravention of the law, and that now that this is some third violation of his probation at this point, I don't think that there's any more leniency that he should be given in this case, Your Honor, and I think that at this point, the only thing to do is unsuspend the 20 months that he bargained for, Your Honor.
Your Honor, can I have a few moments to follow up? First off, just for the record, I think that he went to Keaton in 2022, not 20. It was not part of the original sentence. It was part of, admittedly, the second violation of probation resolution, resolved on May 10, 2022. The second thing is, I've known Mr. Cooper a long time. I was his lawyer in the 20 CF case. He was 20, I think he was 21 years old when that happened. He's had some legal difficulties since then and some technical violations. He's not, we're not, obviously, we cannot, and I am not trying to whitewash anything. I do think, and this is subjective and I'm not a witness, but I think that there is a change in his life in terms of his demeanor. When I was dealing with him 3+ years ago, there were lots of issues of defiance. I don't see anybody who's behind hiding behind a young man's self-delusions or defiance at this point. I think we're basically faced with a young person who's an addict, who's very frank about it. And the last thing I wanted to say is that it is respectfully, I understand Ms. Sharpless's position, but I do think it would be good and it is commendable for all his problems that he is asking for treatment. If Keaton was a 6-month program, Phoenix House is a 12 to 18 month program, so he could very easily be having 24 months in a secure treatment facility if he gets what he's asking for, which is more than the 20-month suspended sentence, which is still going to be hanging over his head if, God forbid, he messes up this probably last chance at a treatment alternative. I know it's very unusual to have back-to-back treatments like this, and as I stated in the letter, it's not saying that he deserves it, but it's saying that he wants help, and I beg the court to please give him that chance. But I say that without any, I'm not proud that we're here, but I am wanting this guy to get some help, and I know that he's got a real good chance if he gets this. Thank you.
Final word. State.
Your Honor, just that frequently people do not even get a second chance at their probation to go to Keaton from the state attorney's office, and now Mr. Cooper is asking to go to yet another residential rehabilitation after he already scores prison, Your Honor. And at this point, again, the state is asking for the court to unsuspend the suspended sentence for this third violation of his probation.
The court has every reason to deny the defendant his request and to acquiesce to the state's request for the 20 months. It's not unreasonable. There have been multiple occasions. people that are involved in the court system. We really are the front lines of the drug addiction crisis in our country. We see it across the spectrum from criminal to dependency with children to injunctions to family. And it's a travesty, and it's coupled by, yours is complicated by the fact that even though you're an adult, you're still young. And I'm going to send you to Phoenix House. And I'm going to do it because, one, I don't think it, I think that the public will be safe there. You're not going to, if you leave Phoenix House, you'll be picked up and brought back in. Addiction is a difficult thing, and you know, just because you get sent off to Keaton, addiction sometimes takes a couple hits. But I will tell you, addiction is difficult, but addiction has no chance if you don't want to change. It ain't about somebody helping you. It's about that. It's got to start with you. You know. It was. I don't normally quote athletic sayings, but one that came into my mind. I forget who the coach was. A great coach. He used to say that the harder I work, the luckier I get. And it's kind of like that. In other words, it's got to start with you. The more you make your own effort, the more you will find that other people will also want to help you. And we do all need help, and you need help with this, and I appreciate the fact. The other reason why I'm doing this is that if you fail here, you'll be back here and you'll be serving your 12 or 20 months or more. But you'll be back if you don't get this. So I'm taking a chance on you that you can be productive. You know, when they recently was seeing some of the film clips from Saving Private Ryan. Do you remember that movie? Remember what happened at the end? The guy was at the cemetery because the guy that had found him, what did he tell him? He said, he grabbed him. He said, make something of yourself. Make your life worthwhile. That's what I'm telling you. I'm telling you, make your life worthwhile. If you say, well, thank you. It ain't about, you don't have to thank me. It's not even the court system. Make yourself something to be proud of, you know, in your community, and reach out and help somebody else and build on that. I'm going to give you another chance. There's no reason to, but I don't think there's any harm in it either. Because I believe that if you don't, one, you're not going to, hopefully you won't cause anybody any trouble and hurt somebody, but if you fail on this, you'll be back here. But I don't want you back. I don't want to see you again. I won't see you again. I sincerely want you to be successful. But anyway, enough preaching.
Your Honor, may I ask for a couple clarifications?
Sure. Yeah, I probably wasn't clear on everything.
Just for the record, so this would be a reinstate and modify. He did a 3 years reinstatement, 3 years probation on May 10, 2022. I think that there should be 30 months probation. No, I think there should be, originally it was June 22, 21. So Does probation see any problem with a new term of 3 years probation, or should we just say the balance? Should we ask the court for the balance of the 3 years that was imposed on May 10 to be on the safe side?
Either way, is it okay either way? State?
I just want to have it.
No, I understand.
I'm trying to do
Yeah, I
that math
appreciate
here.
that.
Yeah, I'm trying to do that math, Your Honor, so I can make sure we don't.
He's going to have to come out to supervision, and
Right.
it's just a matter of whatever's legally he's allowed to have.
Right.
I'm sure he's grateful for the chance. And there would have been also some administrative tolling, so.
So what we're gonna do is you'll go into Phoenix House for their program, but you'll be on longer probation. And actual Phoenix House will be a condition of your probation.
Yes, sir.
So it'll be within your probation, so maybe you have 30 months, that's what they're trying to figure out the number. With 30 months of that, and then, you know, if you have 12 or 18 months in Phoenix and you get out, you'll be on regular probation, just so, you know, hopefully somebody can keep tabs on you, and hopefully you'll have some support. That's one thing you'll learn when you get in there, that you gotta find some support mechanisms.
Yes, sir.
Your Honor, is this, bars to bed?
Yes.
And Officer Prophet made me aware that Phoenix House has a 6-month waiting list. I just want to make sure the court was aware of that he might be waiting. I don't know how long the list is right now, or if a bed comes open. I just want to make sure you were aware that probation.
I don't know anything about that.
Let me know that.
Brother, could we do it this way? Whatever the probation will be available on a 5-year probation sentence, less any time that he's already served on probation. I think that would be a legal sentence. 5 years probation, less any prior probation time in this case. And then it's maxed out at whatever that can be.
I think.
But the bars to bed means basically you gotta stay in. I'm sorry. You can't move any quicker, I know.
5 less whatever probation
You're ready to
time
head out of
is.
jail.
And
5 years probation, less any time.
Go ahead.
I just want Mr. Medina to hear this.
Mr. Medina?
I was going to ask the court if it would not reimpose the 20-month suspended sentence. The state's asking to.
Yes, we would ask for that.
That's fine. That's fine.
Thank you.
Yes, and Your Honor, just for the record, $100 DOP fee and $150 public defender fees.
Yes, and waive supervision on any of the probation costs going forward. Can I do that?
I'm sorry, Your Honor, say that
Can I
again.
waive any supervisory fees?
I don't have a problem with that, Your Honor. Thank you.
Thank you, Your Honor.
Okay. Don't screw up and make me look bad.
Yes, sir.
The state's already mad at me for overriding.
I appreciate it.
Okay?
Good luck, man.
Appreciate it.
Okay, thank you all very much for your assistance today, as always.